Welcome to the webinar of the Israeli-Turkish webinar for the preparation for the two national groups before the conference in October 23. Today we gather, I think, the best speakers that we can find about the Israeli patent law, the Turkish patent law, and the bridge between the two countries. Okay, I'm Eyal Bressler. I'm the moderator for this session. I'm a patent attorney at law, and IP arbitrator. I'm patent attorney for many years, and I'm a chair of the AIPPI Standing Committee for Development and IP. Israel and Turkey are collaborating for many years in large volumes. In the last few years, the import and export of the two countries was exceeding $7 billion in many types of goods. And in January 2020, both states signed establishment of free trade area between the territories and the countries, and the export and import of both countries was elevated in a very significant manner. As we all know, IP and trade are coming together. They are two related brothers. So the goal of this meeting today is to present in a nutshell the Turkish IP system and then the Israeli IP system, and then tell something about the wonderful conference we'll see in the winter. Now, as many knows, Turkey has a very long tradition of IP. It's one of the most experienced nations in the world in IP. Their guild IP laws began in 1727, Gedik laws, and then they adopt the French, the Code Napoleon, the French patent law, in one of the first to do so in the West. They bridge between Asia and Europe for many years, and together with a vast experience and tradition in IP, Turkey is very important state in producing and in the commercialization of many goods. The opposite direction, Israel is very young nation. Our patent laws begin somewhere after the 48 Independence Day. Our patent law is from 68, and we are now filing our new laws. Ugur will speak about the collaboration of Israel and Turkey in patents and about the Turkish system, and Ran will explore Israel as a startup nation. Afterwards, Melis will present the conference in the very few minutes we left in the end. We'll have final Q&As. So if you have a question to raise or opinions to underline, please wait for the end of the session. We are about 60 participants, which is a wonderful number, some of which are from Israel and Turkey, some of which are from other territories. So we are very happy to see you all here. I will conclude my very short presentation with the thanks, many thanks to AIPPI events, Cynthia and Marie, which were very helpful all along the way. for the whole AIPPI Turkish National Group, and especially for President Irmak and our collaborators in the Israeli National Group, and our President Asa Kling. Due of personal reasons, he cannot be here today. And of course, my thanks is for the distinguished speakers and for you all the participants here. Thank you so much. So with no further ado, and before I'll give you a screen to Ugur, I just present one of the most experienced people in the screen here. Ugur is a mechanical engineer. He's have a strong background in technology and science. He was the founder president of the Turkish Patent Trademark Office. He's running the Yulsir Patent Office. He's the acting president of the Turkish Patent and Trademark Attorneys Associations in the last 10 or more years. He is the panelist in WIPO and the Toby Room for domain name dispute resolution. Welcome, Ugur. I'm very happy to host you. I will stop my share and you begin your share.
Thank you very much, Eyal. First of all, I'm sorry. Okay. Thank you very much, Eyal. And I want to say hello to everybody who participated in this seminar today. Let's start my presentation. I would like to talk about today IP rights in Turkey. In short, IP protection in Turkey. In my presentation, I would like to talk about historical background of IP protection. Eyal has talked about something about the IP protection historical background in Turkey and Israel. I will pass that part in short. And I will talk about national legislation for IP protection in Turkey and international agreements which Turkey is a party. And lastly, I would like to give some information about the statistical information about IP filings in Turkey. Now, we know intellectual property is a huge subject, and it covers many sub-subjects. Intellectual property, authors' rights, related rights, and industrial property, trademark, patent, and others, and all other rights. We can easily say that all these rights are protected in Turkey. There is a problem. Okay. Now, when we look at the historical background in the world, the first protection of patent is started in 1474 in Venice. And after that, France, UK, USA are the first pioneers in the world. But at the end, end of 1880s, before the Paris Convention, adoption of Paris Convention in the world, Turkish Ottoman time, Ottoman trademark law, and also 1879 Ottoman patent law entered into force during the Ottoman time. In Turkey, the most important developments in IP started in 1990s. During that time, there was different changes in the world. One is World Trade Organization agreement was talking about, and then Turkey was negotiating with European Union for the customs union, and there were some international developments. In those days, Turkey decided to establish a strong, efficient, and contemporary industrial property and also, of course, intellectual copyright system. When we look at the basic elements of the IP system, there are two parts. One is industrial property system and another part is copyright system. In the industrial property part system, Turkish Patent and Trademark Office is the administrative authority who manages all the IP protection registrations. On one side, there is patent and trademark attorneys, and also national and international legislation, and finally, specialized IP courts. So Turkey established IP courts beginning of 2000s in order to solve the disputes for the IP, including copyright and also industrial property, patent, trademark, and other matters. So most important development changed in Turkey in 1994 and 95. Turkish Patent and Trademark Office established in 1994, and all patent, trademark design laws and other laws and international agreements have been adopted in those years. And Turkey made another revolution in 2017 by changing all the previous laws and adopting a new law, industrial property law. It is also in force now in Turkey. In Turkey, there are specialized patent competent courts, which is called as intellectual and industrial property, civil and criminal courts. And these courts are dealing with all the IP-related court cases. When we check the membership of international organizations of Turkey and also international agreements, first we can say that Turkey is member of World Trade Organization, and also Turkey is member of WIPO. Turkey is one of the establisher founder members of EPO, starting from 1970s, 73 and 78. Turkey is member of European Patent Organization. Turkey is not member of European Union Intellectual Property Office, which is EU IPO. And the reason is that Turkey is not a member of European Union. When we look at the international agreements which are related to industrial property and copyright, so Turkey is member of WIPO Convention and also World Trade Organization Convention and also TRIPS Agreement. Turkey is party industrial property, Paris Convention, and in copyright, Turkey is party Berne Convention, Rome Convention, copyright, WIPO Copyright Treaty, and WIPO Performances and Phonograms Treaty, WPPT. When we look at the general agreements, global protection agreements for industrial property, Turkey is member Madrid Protocol, not Madrid Agreement, only Madrid Protocol, PCT, the Hague Agreement, and Budapest Treaty for microorganisms. Turkey is not member Lisbon Agreement, which is related to geographical science. There are some reasons for not being a member of Lisbon Agreement, because Turkey is has a lot of different products to be protected under geographical science. So Turkey did not decide to participate in Lisbon Agreement until today. Turkey is member Locarno Agreement, Nice Agreement, Strasbourg Agreement, and Vienna Agreement. In order to protect patent or utility model, in Turkey we have patent and utility model, separate protection type for inventions. An applicant may file directly to Turkish Patent Office, direct application, may use EPC route, may use PCT route. PCT routes can be used in two ways. One is national entry via directly Turkish Patent Office, or Euro PCT route. In Turkish entry, it is needed 30 months plus 3 months from the earliest priority date. In Euro PCT route, it is 30 months plus 1 month, 31 months. So if any applicant misses the PCT national regional entry to Turkey via EPO, then they can use 30 months plus 3 months, 2 more months additional duration to enter Turkey to protect their inventions by patent or utility model. When we look at the trademark applications, European patent applications, I can talk about the Turkish European patent attorneys are also authorized to represent everybody in the world in front of European Patent Office. In Turkey, we totally 91 active European patent attorneys, which are registered in the registry of AIPPI. They are Turkish nationals, and they can also represent Israel applicants in front of European Patent Office. There are very, very good colleagues in Turkey representing many national and international companies in front of European Patent Office as a representative of the companies. So Israel companies or Israel colleagues, patent attorneys, can work Turkish patent trademark attorneys to represent their clients in front of European Patent Office. When we look at the trademark protection, Turkey is member of Madrid Protocol, so the applicants may use direct application to Turkish Patent Office, or they can use Madrid Protocol route by using WIPO to file applications in Turkey. For design application, Turkey is member of the Hague Agreement, so the applicants from other countries may use their design applications to file to Turkey by using direct application or by using the Hague Agreement route. Both is possible. For geographic indications, geographical signs, Turkey is not member of any international agreement like Lisbon Agreement, so it is needed only to file direct application. In geographical indication protection, direct application is valid for foreign applicants, but it is obliged to prove that the geographical indication must be protected in the home country, and the control of the geographical indication processes must be valid in the home country. Those must be proven in Turkey. When we look at the patent and trademark attorneys, in Turkey, patent and trademark attorneys, we have two separate patent and trademark attorneys system. Trademark attorneys are authorized for trademark matters, geographical signs matters, and designs matters, and they can represent their clients in front of Turkish Patent and Trademark Office. So, in order to for the patent attorneys, they are authorized for patent, utility model, industrial design, and topographies of integrated circuits. They can represent their clients in front of Turkish Patent and Trademark Office. In order to be a patent or trademark attorney in Turkey, the candidate must have bachelor degree, at least 4 years higher education degree, and they must pass the exam, which is held by Turkish Patent and Trademark Office every 2 years. Not every year, every 2 years. This year is the year to take the exam. And also after completing the exam and passing the exam, the attorneys who passed the exam must register into the Registry of Patent and Trademark Attorneys Registry. This is essential to work as a patent and trademark attorney. In also patent and trademark attorneys, in Turkey, there is no separate independent chamber or union or something else for patent and trademark attorneys. In Turkey, there are some associations. One of them is AIPPI Turkey, is the biggest one, having the highest member. The other one, Patent and Trademark Attorneys Association, and also another one, AIPPI. These are very active organizations, and they cooperate each other. And all the members cooperate each other. They have very good, close relations. At the end of my presentation, I would like to talk about some statistical information about applications, IP applications in Turkey, with special reference to applications by Israel nationals. When we look at the patent applications in Turkey, the total patent applications in the year 2022 is about 15,000, about 16,000. Some of them is domestic applications. Domestic applications, 9,000 is higher than the foreign applications. This is the figures of the last year 2022. Before that, all the foreign applications were higher than the national applications, like in all countries. But in Turkey, last year, it has changed. We couldn't find the answer to this change because there are the very sharp decrease in European patent validations in Turkey also. When we look at the Israel applications, here starting from 1995 until 2021, totally 1,189 patent applications filed in Turkey by Israel nationals. When we look at last years, for example, 2018, 103, 2009, 106, but 2021, it decreased to 77. When we look at the trademark applications in Turkey, the trademark applications is highest in the world. We don't know the reason why, but Turkish applicants are filing a lot of trademark applications. In the year 2022, totally 212,000 applications, more than 200,000 trademark applications filed in Turkey, Turkish Patent and Trademark Office. And most of them are national domestic applications. Some of them foreign applications. All of the foreign applications are coming from the Madrid Protocol. When we look at the Israel applications, we had 977 Israel applications, trademark applications, in last about 20 years, 18 years. This last year, 2021, there is only 66 applications from Israel companies to Turkey. When we look at the design applications in the year 2022 is about 20,000 in Turkey. Some of them are coming direct applications, some of them are coming hard route. These are foreign applications. But the domestic applications are also higher. Finally, 117 total applications, design applications filed in Turkey by Israel nationals in last about 18 years. So I would like to thank you for your kind attention in my speech. And if you have any question, of course, I will be very happy to reply all your questions. Thank you very much.
Thank you. So thank you very much. I really thank you for the informative and important presentation. Before we continue, I just want to say that our session is recorded, and now that about 73 people are participating, I will ask both Melis and Ran to welcome this session. So Melis, if you can, please.
I will start.
Okay, so
okay,
you're the one.
Okay, so first, many thanks to all who joined this webinar from a very large group of countries, and thanks also to the AIPPI international team who helped a lot and made this webinar possible. The Israeli group of AIPPI are very happy to cooperate with the corresponding group in Turkey. We are happy about the opportunity to promote the ties between the countries, to learn from each other, and especially to get to know each other. I hope that most of us will also be able to meet in person, face to face, at the Congress in Istanbul that I think all of us are very anticipated for him, and especially to promote the cooperation between the countries. Thank you.
Melis, the floor is yours.
Thank you, Eyal. Welcome and good afternoon, everyone. Thank you to each and every one of you for being here with us today. My name is Melis Abacıoğlu. I'm the Vice President of AIPPI Türkiye. Today, we had the privilege to organize a joint webinar with AIPPI Israel regarding the general overview of IP rights, both in Turkey and Israel, and also talk about our upcoming World Congress. As you all know, this year, we also have the privilege to host all of you in Istanbul. Istanbul is Turkey's largest city, and it is the world's only city on 2 continents. The vibrant and modern city of Istanbul is the bridgeway between Asia and Europe. The Bosphorus divides the city into 2 continents. Istanbul means a rich history in a modern setting. It is one of the cities with the richest history in the world. The city faced the rise and fall of many empires, such as the Roman Empire, the Ottoman Empire, and later on Turkish Republic is established. So this is an eclectic place, unlike anywhere else, where ancient means modern. Turkish group is now very much excited to welcome you in Istanbul and taste the Turkish culture together. I would like to thank to AIPPI Israel for sharing our excitement for the upcoming World Congress, bringing up this idea and teaming up with us for this joint event to exchange our practices. It is our pleasure to be with you today. And also, I would like to thank you to AIPPI International to support us in the organization of this webinar.
Thank you so much, Melis. Thank you so much. Coming again to our session, I will remind everyone that the session is a Q&A final stage. So if you have question or if you want to chat, you can use our tools just below your screen. I want to present now Ran Vogel, but my presentation is not so good. Sorry for that. Try again. I try again. Sorry for that. Okay, I cannot do it, so I'll do it by
say some nice things.
All the way. Ran Vogel is a well-known Israeli patent attorney working in a well-established Shin Horowitz firm, which is one of the biggest and most experienced firms in Israel. He's an expert in IP. Has a lot of work as the AIPPI secretary. Oh, thank you so much. As an Israeli secretary of the national group, is also very, very active in the AIPPI multinational work. His work is wide spanning. Is working with universities and both in startups in pharma, life science, food tech, telecommunication, and many other sectors. Ron is I'm very delighted to hear you now. So please.
Okay, so let me share my screen. Okay, everybody can see my screen? Okay, so I think in the framework of 20 minutes, it is not possible to review the IP laws in Israel, even briefly. So I would like to begin with relatively formal review of the IP law in Israel with a very brief reference to issues that may be relevant to non-Israeli citizens. After that, I will again briefly review how the fabric of IP rights in Israel assist Israel to stand at the forefront of global technology. Start with the patent law. Even though the Israeli patent law is from the year of 1967, which originates from the English law from the year 1949, it is a modern law, which was amended several times in the past. For example, the patent law allows obtaining a patent term extension. It includes a Bolar exemption, which allowed the use of invention for obtaining the regulatory license. It's very unique exemption because this exemption applied not only with respect to experiments conducted for obtaining license in Israel, but also with respect to experiments conducted in Israel for obtaining license in other countries where Bolar exemption exists. I will refer to the Israeli patent law within a few minutes, but at this stage, I will point out that Israel has a pre-grant opposition system, which allowed any third party to oppose to a patent application that is accepted for registration after the examination proceeding. This system allows the validity of a patent to be decided before it can be enforced. Some other points, no criminal liability due to patent infringement, only civil remedies. You're hearing now, I think, a startup company that celebrating beneath me. Finally, at this stage, patentee is entitled to a final injunction, even in cases where the plaintiff does not use the invention, meaning non-practicing entities. The US approach in the eBay case is still not adopted in Israel. The law applicable to trademark in Israel was also mainly adopted from the Old English law. At the same time, like the patent law, it has been amended quite a few times. One of the significant amendments, which is relevant to owner of trademark outside of Israel, is the amendment regarding famous trademark. As you can see, the definition of famous trademark also refers to situation in which the mark is not registered in Israel, and even in relation to situation in which it is not used in Israel. Accordingly, owner of a foreign trademark can enforce the rights in Israel in cases where the mark is well known to the Israeli public. I gave some example of a Turkish well-known trademark in Israel that I don't know if they're registered or not, but they can definitely be enforced in Israel. Another relevant point for trademark owner outside of Israel is that Israel is a member of the Madrid Agreement and the Madrid Protocol. Additional laws in the field of IP were adopted in Israel from Old English law, but unlike the patent and trademark law, Israel has enacted new laws relating to design, copyright, trade secret, and the passing off. The design law allows for protection of registered and unregistered design in Israel, but there is a significant difference in the protection period, 25 years for registered design and 3 years for unregistered design. But at the same time, the owner of unregistered design, which has achieved commercial success, may register it during those 3 years year period and gain protection for the longer period. Other laws in the field of IP are, of course, the copyright law, which is relatively modern in Israel, and the commercial tort law, which includes statutory protection for trade secret and passing off. Also, many IP rights are protected by legislation in Israel, appellant of origin, geographical indication, planet breeder, integrated circuits, broadcaster and performance right, and unjust enrichment law, which is like an umbrella that in specific situation may apply to IP rights that are not protected by the formal IP laws in Israel. I would like to address now the question of how the IP laws in Israel encourage innovation and, together with other important factors, help Israel stand at the forefront of global technology. So let's start with some facts relative to its size and the number of citizens and few geopolitical problems and challenges. Israel managed to compete with the world's largest hub for investment in startups. The Israeli high-tech has succeeded in serving an engine for the Israeli economy. There is more than 9,500 startups currently active in Israel, 380 VC funds operating and investing in Israel. $95 billion over the last decade was invested in Israel high-tech industry. Israel is ranked first in number of startups per capita, first in the number of VC invested per capita. Moreover, I think in the last 20 years, the Israeli high-tech sector had gone through a healthy process. It was a process in which Israel became from the startup nation to the scale-up nation. Over those years, the experience gained by many employees and managers, together with the significant venture capital investment, have allowed many startups to develop into a complete high-tech companies, the unicorn, and establish a global business activity. Of course, it is not possible to refer to the many fields which high-tech companies operate in Israel and around the world, but I want to refer to 2 fields that are close to my heart, that are related to each other, the food tech industry and the climate tech industry. In these two areas, Israel is one of the leading countries in the world, both in number of operating company and in the IP created here in Israel. For example, Israel is second only to the US in the field of alternative protein. As far as the climate crisis is concerned, 836 companies are currently operating in Israel, trying to solve various problems in this important field. And as you can see in this slide, many cutting-edge technology were developed here in Israel, including disc-on-key, cherry tomatoes, Waze, Mobilize, and additional long list. Israeli dynamic innovation ecosystem is heavily relied on IP to fuel its success. Inventors seek assurance that their investment will be safeguarded, and robust IP rights provide this confidence, tracking crucial funding for startup and technology companies in Israel. IP protection is essential for Israel innovation to succeed in global markets. Strong IP system enable Israeli companies to compete effectively on the international stage. IP discussion in Israel ecosystem always emphasize the importance of striking the balance between protecting IP on the one hand and encouraging innovation through on the other end. And as I will show later, the IP laws attempt to have been made to create this balance. Israel is not just a startup nation. Many multinational companies have found in Israel a suitable home to establish R&D centers. Israel has a robust legal framework for IP protection. It offers patent, copyright, trade secret, and trademark laws that align with the international standard, providing a secure environment for companies to safeguard their invention and creation. Israel has implemented a streamlined process for patent registration, allowing companies to obtain patent protection more efficiently. The Israeli Patent Office has implemented measures to expedite patent examination and reduce the backlog of patent application, which can be advantage for companies seeking to protect their IP. Of course, it is not enough to have efficient and effective IP laws to attract a multinational company and an investment in Israel. There are other incentives such as highly skilled workforce and strong academic ecosystem, government support, and access to global market. I think like Turkey, Israeli strategic location provide multinational company with access to global market, including Europe, Middle East, and Asia. Since the principle of fairness, due process, and non-discrimination are still fundamental aspect in the Israeli legal system, the system provides equal treatment and protection to all individuals, regardless of their nationality or background. When it comes to IP law, Israeli court aim to apply the law equally to both Israeli and non-Israeli individuals and entities. The law regarding IP rights, including, again, copyright, patent, trademark, and trade secret, provide the same legal protection and remedies to all parties, irrespectively of their nationality. In addition, as you can see from the next two slides, Israel is a party to various international IP agreements and a convention. These international agreement and convention ensure that Israel IP laws are aligned with the international standard and provide the basic for international cooperation in protection IP. Apart from commercial consideration, which are important, there are several reasons why Israel is a very attractive country for registering patents. First, English is the governing language in patent prosecution in Israel. In addition, it is possible to obtain a patent here in Israel actually with no examination based on corresponding patent granted in the US, Europe, or other jurisdiction. Another option is to apply for accelerated examination through the GPPH route. Furthermore, there is a special program for priority applications that are filed in Israel. According to this system, a search report in English can be issued within 3 months after the priority date. And in cases of a successful accelerated examination, the applicant can apply for GPPH prosecution in many other jurisdictions based on such a positive outcome in Israel. I'm not a patent attorney, but I've been told that it is possible now to obtain a patent in Israel after 12 months, which is wonderful and can assist in other jurisdictions. Finally, and hopefully within few months, the Israeli parliament will amend the patent law, allowing filing provisional application in Israel, similar to the US system, similar, but not identical. We don't know the final version yet. Therefore, it is not surprising that there is a constant increase in patent application by a foreign applicant here in Israel, as you can see in this slide. As I mentioned at the beginning, the IP law in Israel tried to create a balance between innovation and IP protection. For example, generally, Israeli courts do not discuss the question of patent validity in PI proceeding, preliminary injunction proceeding. The patent is considered valid. Therefore, in cases where a defendant does not have a good non-infringement argument, but rather rely on invalidity argument, it is likely that PI order will be issued against him here in Israel. But on the other end, and as I mentioned in the beginning, in Israel there is a pre-grant opposition system which allowed any third party to oppose a patent application that is accepted for registration. These systems allowed the validity of a patent to be decided before it can be enforced. Therefore, a potential defendant can file an opposition to a patent application, so avoiding a PI motion until the validity of the application is decided. Furthermore, under the unjust enrichment law, a patentee who obtain a PI may compensate the defendant if at the end of the legal proceeding, his main claim is denied. In addition, in a situation, I think this is very unique to Israel. It's a very new law that still pending in the Supreme Court. In situation in which patent was obtained by misleading the patent examiner, the patentee will be exposed to damages if a competitor can prove that the said patent that was obtained by misleading the patent examiner delayed his entry to the market. Finally, both applicant and any third party can apply to an accelerated examination of patent applications. The applicant to prevent or to stop potential infringement, and on the other end, the third party to enable him to know whether the field he intends to enter will be protected by patent. Last point I want to mention, because my time is running out. There are several laws in the field of IP in Israel that allows goods suspected to be infringing to be detained at the custom, even before a legal proceeding initiated. The custom officer do their best to locate infringing goods and immediately inform the right holders. Thereafter, a legal proceeding can be initiated. Thank you very much for your time.
Thank you so much. Thank you so much, Ran. With no further ado, we'll go to Melis. Melis is the Vice President of the Turkish National Group. Oh, thank you so much. She's partner in the Turkish firm AIPPI, AIPPI. Sorry for that. I cannot read Turkish. She's registered attorney in the law at Ankara Bar and qualified trademark patent attorney before Turkish Patent and Trademark Office. She's both handling prosecution and litigation matters, and she's representing local and international clients with special focus on trademark, copyrights, anti-counterfeiting, and unfair competition and plant breeders' rights. So, Melis, why should we come to the already coming conference in Istanbul? Melis, you are muted.
I'm so sorry. I'm going to explain in brief now why to come to World Congress. Although there are many reasons, I'll try to be brief because we are about to run out of time. Let me share my presentation. Is it okay? So, our Congress will be between the days 22nd and 25th of October. And the conference venue is, sorry for this. Can you see it in the slides mode? Is it in the slides mode now? Is it okay? Perfect, okay. The conference place is Hilton Istanbul Hotel. The hotel for the Congress is, we can say that it's in the heart of Istanbul's commercial areas, and it is very close to the historical sites. So we choose it very carefully. Here are the registration deadlines, and the early bird registration deadline will end very soon on 6th of July. So don't forget to complete your registration to be able to benefit from the early bird registration rates. 5 reasons to attend to the Congress. I can make a summary of the 5 top reasons to participate in the World Congress as attending the educational program on major IP hot topics. Of course, as well as usual, taking part in adopting the AIPPI resolutions. Networking with IP friends and colleagues from all around the world. Experiencing the city where Europe meets Asia. And enjoying multiple social events at exclusive venues. This is the program at a glance. I'll give you a short brief about the content. As you know, the major achievements of our World Congresses are always the process of adopting the resolutions. This year, we will adopt the resolutions on these following topics. The patent study question is about doctrine of equivalence. Trademarks is dedicated to proving trademark use. Copyright study question is about collecting societies, and a very popular topic, general study question is about responsibility of online marketplaces for online infringement. And in addition to study questions, the World Congress has more than 20 panel sessions and within the educational program. The topics of the panel sessions are carefully chosen to cover major IP hot topics in all areas of IP, such as metaverse, NFTs, pharma sessions, and so on. We also gonna have 3 networking launch sessions in interesting topics, and the UPC mock trial will be organized with the participation of EU judges. And also a large number of AIPPI cafes will be held within the scope of the program. I think it was about 14 AIPPI cafes as well on first come first served basis. And with AIPPI Bureau, we had inspections, and I believe we have chosen the most magnificent, most amazing places for the social events. The Congress will start with the Council of Presidents dinner in terms of social events. It will be in Chiran Palace, Kempinski. This is the only Ottoman Imperial Palace, and this is the hotel on the Bosphorus with a stunning view. The event is invitation only. And then comes the opening ceremony and welcome reception, which will be held in the conference center. For the cultural evening, we have chosen a very historical place. The name is Binbirdirek. This is the second largest water reservoir in Istanbul, and it gives really a magical atmosphere. We believe that the participants will enjoy the most. And Young AIPPI Forum will be in an iconic venue named Babylon, and it's located very close to the conference center. In the last day of the conference, for women in AIPPI, there will be a boat tour for the ladies, and there will be some other surprises, like the opportunity to take belly dancing lessons, and so on. After Women in AIPPI, we're gonna have the closing dinner in Hilton Bomonti Hotel, but now in another atmosphere. There will be an Ottoman theme for the closing dinner. And after the closing dinner, we're gonna have an after party in Babylon. So registration fees, just don't forget to get registered until 6th of July, because it will gonna increase soon. So to be able to benefit from the registration, early bird registration fees, please complete your registration. And we are also sponsored by Turkish Airlines. So there are some special discounts offered to all of the attendees, like 20% and 10%, and there's a discount link and code available on Congress website. Lastly, the sponsorship opportunities are still going on, so you can check the website for the sponsorship brochure and become a partner of AIPPI for sponsoring the World Congress. So we are very excited to seeing you in Istanbul, and for any questions, you can also write to registration at AIPPI for the registration things, and of course you can always contact our group as well. Lovely to have all of you here today, and we are very excited and enthusiastic to welcome you in Istanbul.
Thank you so much. Wonderful presentation. For the Israeli guys in this webinar, it's only 50 minutes of flying, and Istanbul is the most beautiful place in the world, so we should come all. Now we'll go to the Q&As. Sitting with me is Dr. Karin Feinberg that gathered a few questions from the audience and from the people, and I have a question to you all, Ugur, Melis, and Ran. Marcus Zhao asks about the difference between designs and industrial designs. Ugur, I think it's for you. You are in news.
Yes, I read the question. Before 2017, the Turkish legislation was talking about designs as industrial design as European Union. Now 2017 we changed it from industrial design to design. In my slide, only the patent part it state as industrial design, or it means that design. So in Turkey we call it as design protection after 2017. That is the explanation of this difference.
Thank you, Ugur. Another question raised here is how the Turkish and the Israeli governments encourage and support research and development and commercialization of technology, and whether the governments as opportunities for mutual research and mutual development and commercialization. In Israel, entrepreneurs can reach up to 30% of support of the government. The support of the government is from 30% to about 70%, up to $1.5 million US dollars. And the Israelis are using this money quite a lot. The money is not to be. The money is a grant. You should not. It's not for shares or something like that. And if you succeed, you should bring the money back to the government. If not, this is a risk money. So, do you have in Turkey something like that Israeli or other people in the developing countries can reach you and have your advice in research and commercialization there in Turkey?
Yes, I can say some incentives for or support from government for Turkish people only now. One is the official fees of PCT applications by Turkish nationals or Turkish citizens, people residing in Turkey. The official fees are paid government, Scientific and Research Council. Additionally, Scientific and Research Council is giving incentive for valuation of the patents for commercialization of the inventions. Mainly the commercialization of inventions are made in the technocans in the techno policies of the universities. There are many techno policies in the universities, so they are supporting inventions, inventors, private inventors or small, medium enterprises, and the Scientific and Research Council is supporting for valuation of the invention. It's not so much, but it is also good for the inventors to see the value of their invention, the value of their studies and others. There is no special incentive for the foreigners, but of course there are some other research and development incentives in different ways. So those can be a joint venture of nation-led international companies. which is different from the IP?
Thank you, Guru. I just want to mention that in Israel, the situation is still very optimistic. That if one of the joint venture is Israeli, so especially in agriculture and food tech, medium tech, electronics, and some of the Turkish startups wish to join, either it is a university or startups, there's still fundable money here in Israel, so you are welcome. Israel was a territory of Turkey for 400 years, and for the Israeli guys, Turkey is the bridge for Europe. In what way can we, the Israeli people, joint venture with you, the professionals in Turkey, and promoting business of our clients here in Israel, in Europe and in Turkey?
A good question. Yes, Turkey is a bridge to Europe. Turkey is not member of European Union, but Turkey has a customs union with European Union, and there is very close relations with all European countries. And also Turkey is member of EPO, and there are all the patent issues are exactly identical with the EPO system. There are some slight differences, but not important. EU IPO, or Turkey is not member, but all the EU IPO procedures for trademarks and designs are similar in Turkey. So the Turkish companies, there are some Turkish companies having joint ventures, semi-cooperation with Israel companies in Turkey. Some we know in defense industry, and also some other new technologies. But I cannot say anything about how we can improve this at the moment. But the patent attorneys and also trademark attorneys, we may, Turkish and Israeli patent trademark attorneys may help some cooperation to improve the relationship between Israeli and Turkish companies in both countries and also Europe and in the world.
Thank you very much, Guru. I think the last question is for Ran. I know that his time is running very fast because there's another meeting. But Ran, I have a question for you. When I saw the slides of Guru and you, I saw quite a difference between the filing patterns of the two countries. In Turkey, most of the filings are local by residents of Turkey filing in Turkey. Whilst in Israel, most of the filings are about foreigners. So what is your opinion? Why so many people are filing in Israel and why are they filing outside Israel?
I think the question is not why many foreign companies and individual register patent in Israel, but rather Israeli companies register patent in other jurisdictions, because Israeli market is relatively small market, and most Israeli companies focus on global markets. So for them, I'm not sure that the Israeli market is relevant, and the patent here is relevant. And another issue, since there is a lot of startup companies here in Israel and a lot of generic companies in the pharma industry, multinational company register the patent here, trying to sometimes block Israelis generic company or other company that operate and has a manufacturing site in Israel, and to block them, not just all over the world. If they can block it here in Israel, they can block it all over the world. Maybe that is the reason.
Yeah, Got it. Thank you very much, Ron. Thank you, Gur. Thank you, Melis. Thank you very much, the AIPPI event, Marie, Cynthia, and thank you all the 73 participants in this webinar. We all will meet in Istanbul, the best food in the world, or the best location. See you then.
Yeah.
All the best.
Thank you. Thank you very much.
See you in
Thank
Istanbul.
you very much. Thank you to AIPPI Israel International and all the distinguished speakers and participants. See you all in Istanbul very soon.
See you.
Bye-bye.
Bye bye.
Bye bye.